Good afternoon, everyone. This is Rajiv S. Khanna from Immigration.com, the law offices of Rajiv S. Khanna, PC. These are our bi-weekly calls, once in 2 weeks, every other Thursday, where we try to answer your questions to the best of our ability. All answers are subject to the disclaimers that you have heard when you logged into the conference call. With that, let me just first double check that everybody can hear me. Just a moment. Let me check the sound.
The conference is now in conversation mode.
Hey guys, can you hear me okay? Can you hear me?
Yes, Rajiv. Yes.
Thank you. Excellent.
The conference is now in presentation mode.
So those of you who have been in these conferences before, first I will go over the questions that I have marked as frequently asked questions. And of course, I will stop each time for any follow-up questions. Then I will go over the individual questions that are not frequently asked. Again, I'll stop for any follow-up questions. In the end, I doubt we will have time for new questions, but if we have time, we will love to take your new questions and answer them as we go along. The first frequently asked questions are all dealing with the pending I-485. The very first one says, pending I-485 petitions and 180-day portability rule. Two questions. This is question number 2. Number 3. No, strike that. Number 2. Following two questions. First is, my I-140 is approved. It was approved in August of this year. 485 was filed in October of this year. Now it's pending less than 180 days. No green card EAD yet. If my job is terminated, what will happen to my I-485? Well, the good news is you'll be okay. Or you should be okay. The reason, the law does not require you to hold the job for 180 days. Okay? And this is important to understand. Actually, we are fighting right now. We are fighting with the government over a case, and this might end up in court. And if it does, the government will lose. I have no doubt about that. Because the language of the regulations is very clear. The language of the law is very clear. It is just that the 485 should be pending 180 days. I don't have to hold the job. And this has been tested in courts before. The government has lost. So if you have your I-140 was approved in August, you filed your I-485 in October, your 180 days begins from October. And that brings us to about what, January? April, October, November, December, January, February, March, April. Almost there, right? So March. If your case has not been revoked by the government, by March of next year, you'll be fine. But if they get to it and they revoke the 485 before 180 days, then you have a problem. So one of the things you can do, one of the measures to protect yourself, is to request the employer not to revoke your H1. It's difficult, it's required by law, but maybe something in writing can be requested. What happens is when they request for a revocation of the H1, it often becomes a trigger for revocation of the 485. So assuming that your 485 is not revoked, you will be okay after 180 days even though you don't have a job. Or you have another job, you've not yet filed a supplement J, which you shouldn't file until 180 days are over anyway. Okay? So I think you're well protected, but there are a couple of caveats, there are a couple of cautions. Just make sure, if possible, they don't revoke your H1. If they do revoke your H1 and that becomes a trigger for your revocation of the I-485, I would push it like this. If the revocation of the 485 gives me a deadline to respond that goes to 180 days, I would respond after 180 days and I'd say, well, it's been pending 180 days, I'm safe, you can't touch me. You see what I'm saying? So not only am I protected when my 485 is still in process, I'm also protected if it is under RFE as long as my response goes beyond 180 days. That's the way I see it. This one we haven't tested in courts yet, but I think we would win. So all in all, I think you should be comfortable as long as your 485 revocation does not get triggered off. Okay? Your second question is, after getting green card EAD and AP and before final action dates become current, can I go outside USA and work for the same employer or any other employer using EAD? Well, first of all, when you are outside the United States, you do not need an EAD. Why would you need an EAD? You're not working on American soil, right? You're working outside the United States. Have that cleared. Second, as long as you have a permanent job offer, it shouldn't matter whether it is the same employer or some other employer, as long as you're protected by Ac21 Portability, and as long as the employer has continued to employ you or even has a future job offer for you, which is genuine. So you have a lot of flexibility. I wouldn't want you to just go. I would want you to talk with your counsel, your lawyers. Make sure that if a supplement J is now available and needs to be filed, you file it because it gives you many rights. It gives you additional protection. So go ahead and file the supplement J. But the fact that you're working from outside the United States is completely irrelevant. Okay? *5 if you have a follow-up question. No new questions. Any follow-up question on this? Okay. So this is from area code 570. 570, where are you calling from?
Good afternoon, Rajiv. I'm calling from Pennsylvania. This is the person I posted the question.
Yes, sir. Go ahead.
I understand, like, I can, if I go and work outside United States, then that is possible. But
okay, hang on, sir. I have one clarification, which is very important. If you're going to work from outside the United States, I would prefer that your advance parole should be valid for the entire duration of your stay outside. Okay, so make sure your advance parole is valid. I don't care about the EAD, but advance parole is important. Okay.
So when you say valid, it could be like 1 year or 2 years.
Yeah. So let's say let's say they gave you advance parole, which is valid for 1 year. Let's say it's valid till January of the next year, valid till January 2022. So you can be outside USA up until December 31st or 1st. We would want you to come back the day before the advance parole expires. And then you can apply for another extension, wait until the extension comes through, and then you can leave again.
Okay, so that is one scenario. Say in case if I'm working for the same employer, is it possible I can change my locations and work from anywhere else within the United States without any amendment or anything?
Absolutely, because see, the way it is you have two choices when you begin work after the 485. Either you are still using the H1, which I prefer, or you are working on the EAD. If you are working on the EAD, you can work from anywhere in the United States. Nobody cares.
So actually my daughter is like 16 years. So if I choose working with EAD, so my daughter also can go with her EAD, green card EAD, and she can just leave her H4 status. Is that fine?
Absolutely.
Anything
Yeah, her status, okay. Understand something. Status, or loosely, it's not really status. It's called authorized period of stay. But the legal status comes from the pendency of the 485. So if she had no EAD, she just has a 485 pending, she doesn't need H4. Okay. I still prefer everybody have their H1, H4, yeah. But if your circumstances don't allow it, that's fine. Okay. So number one,
so when she goes to college,
number one, legal status comes from 485, not from EAD. When she goes to college, she should be able to go on the 485 pending alone. But if she wants to also work on the side, she will need her EAD.
Okay, Rajiv. All right.
Okay.
Thank you very much.
Oh, you're very welcome. Good luck to you, sir.
Thank you.
You're welcome. Bye-bye. Okay, there's another question. I hope it's a follow-up because we won't be doing new questions. Area code 614. Area code 614, where are you calling from?
From Columbus, Ohio.
Yes, sir. You have a follow-up question? Go ahead, please.
Yes, sir. You mentioned that the employer can revoke 485.
No. Let me clarify. The employer can revoke the I-140, they can revoke the H-1. So I would make a request, and that's an additional point. I'm glad you brought it up. I would make a request to the employer, please don't revoke my I-140 until after 180 days, and please don't revoke my H-1 either. The H-1 is required to be revoked by law, otherwise the employer is on the line to pay you your salary. But if you can negotiate and come up with some kind of a protective language for the employer, I think it can be done. I-140, they don't have to revoke at all. So I'm not worried about the I-140 revocation. That's not required by law. You can probably convince the employer not to revoke until 180 days of pendency of the 485 are done. Okay. But I think it is important for them not to revoke the H-1 because sometimes that becomes the trigger for revocation of the I-140 and the 485. Okay.
Okay. If 140 has been approved like 2 years ago, can you still revoke it?
Well,
185 is pending.
You see, we are talking about two different things. There are some benefits that come from filing the I-485. And there are some benefits that come from filing of the I-140. When the I-140 has been approved and stays approved for 180 days, you have two benefits. One benefit is there on the very first day, it doesn't have to wait for 180 days. First benefit is priority date. You keep your priority date even if the employer revokes your I-140 the following day. Okay. But if the case stays approved for 180 days, the second benefit you have is that you can keep extending your H-1 beyond 6 years with any employer. Okay.
Right.
Now, so that's one set of benefits. There are some benefits that come from the 485 pending 180 days. That's a different benefit. Ac21 Portability, which says once I-140 is approved and 485 has been pending 180 days, the employee can change employers without having to redo the green card. They just have to do a supplement J as long as the jobs are same or similar. Now, this is a different benefit. Okay, so when the 485 has been pending 180 days, you get this additional benefit of being able to transport your green card wherever you want to go.
Got it.
Okay.
Thank you.
You're welcome. Good luck. Okay, next frequently asked question. And this is also kind of a same discussion being followed up. It is about supplement J timing and joining previous employer. I've covered this several times about filing a 485 from an employer that you have already left. And now the question is, how soon should I go join them? Well, first of all, if you look at the law classically, there's no requirement that you join the old employer. The only requirement is that they must offer you the same job, the green card job, in good faith, honest intentions. And you have the same honest intention to join them when you file the 485. After the 485 has been pending 180 days, you can transport to any employer, including staying with the same employer. During an interview, the issue could come up. Did you really have a good faith intention and honest intention to join them? If you did, why did you leave them? And now why are you coming back? So all these issues can be raised. Now, if you have already joined them before the interview, and well before the interview, those issues may not be that important because you already joined that employer. So that is the context. That is the context in which you are working. Okay. So your first question was, do I have to join my old employer? Or is it okay if I join them after approval? And the answer is, well, it depends. You have to talk with your lawyers, discuss your particular case. I can't comment generically, but if I were just asked to comment about the law, I explained the law to you already. As long as the intentions are honest, you don't even have to join them. Is it possible that employer B can file Form J after 180 days? Exactly. I just discussed that. What do you recommend? I would recommend having your lawyers review your honest intentions, make sure that everything is okay, and then if you file the 485 under whatever circumstances, supplement J can be used after 180 days. *5 if you have a follow-up question on this. *5. Okay. There's a question from area code 704. 704, where are you calling from?
Hey Raju, I'm calling from North Carolina.
Yes, ma'am.
Yeah, so I just have a question. So you were talking about the revocation in previous question. So does that revocation applies in my case also, considering I am not on H1, I am on H4 right now, and my 140 is already approved more than 180 days. So can my employer revoke my 485 if I don't join them for next 6 months?
Okay.
After filing 485.
Okay, so let us understand this situation. First of all, you don't have that problem of H1 notification. There is no notification for H4. So you don't have that problem. Let's move that away. The question is, my I-140 is approved. My I-485 has been pending 180 days. If I don't join my old employer or whatever employer, can they revoke my I-140? They can revoke it, but it doesn't affect you. Your green card goes on. Okay. So the weird thing is, under the law, the employer is then, they have gotten rid of the I-140, but as far as you are concerned, that I-140 is perfectly alive and perfectly well. So you are protected, no problem. Okay?
Okay.
Good luck.
So only 140 can be revoked, but 485 cannot be revoked.
Exactly. For the purposes of the 485, your I-140 is still as good as gold.
Okay. And I just have one more question. So because of the COVID, the jobs are very less right now, and also the position that they were offering me is in the area where there are too many cases of COVID and the lockdown and everything. So if I explain this scenario in my interview, if the interviewer asks me why you did not join them in the 6 months, so will this be a good answer for them, or will there be any issue?
I won't comment about your case specifically because I don't know your facts. But let's say there was a case in which an employee did not want to join because of heightened risk of COVID. I don't know if I would be comfortable with that explanation alone, because you see, that means when you filed the 485, you already knew you were not going to join them. Okay. The important point is, when you file your 485, you should have the intention of either keeping the employment or joining the employment. So if your mind is already made up, there's too much COVID, I'm not going to go, then you're not really filing that 485 in good faith. So that's why I said, talk to your lawyers before you make any decisions. Theoretically, it's all possible. Yes, I think if there was a heightened risk of COVID, I think that would be a good reason not to join, especially if that risk developed after you filed the 485. Okay?
Yep. The question was only if I don't join them till COVID is gone.
Yeah.
But after COVID is gone, then I can join them.
I think that is absolutely fine. Why would I want to risk my life for my job? Okay. So yeah.
Okay. Thank you so much, Raju.
You're welcome. Good luck. Area code 614. 614, where are you calling from?
At Columbus, Ohio.
Yes, sir. Go ahead.
This is about the same question. If you don't join the previous employer and they have just filed their 485 and for some reason they withdraw the job offer within 180 days, would that create an issue?
No, because as long as on the date when they filed the 485 or helped you file the 485, they had the intention to hire you, that 485 is perfected. Now, later on, situation develops, they want to withdraw the job offer. As long as the government doesn't revoke your 485 for 180 days, I think you're safe.
How can the government revoke?
These are issues that we don't...
485?
Yeah, we don't talk about these issues because I don't know how it can happen. For example, let's say that your friend next door doesn't like you. He figures out, you know what? His employer has withdrawn the job offer. He picks up the phone and he calls his buddy who works at the Department of Homeland Security. Says, I want to report this employee. He doesn't have a job. I don't know how it can happen. I have seen things like that happen. So, I don't know. That's not the question. The question is, does the government revoke or not revoke? How they find out how they revoke, that is secondary or even tertiary. That's not my concern. And nor should that be yours. Our concern should be, how can we be safe? And the answer is, once the 180 days are passed, after a genuine 485 is filed, the fact that the job offer was withdrawn or you decided not to join should be secondary. Law only requires 485 pending for 180 days. That's it. Okay?
Okay. So within 180 days, the employer can go ahead and ask the government to revoke it.
They shouldn't because, first of all, the 485 is not their application. They can only choose to revoke the I-140. Okay.
Okay. But I-140 has been approved for about 5 years. Then they cannot do that as well, right?
Okay. Now, you are twisting yourself up in knots. I just answered that question. I said I-140 can be revoked, but it is not revoked for your 485. As far as the 485 is concerned, it's a legal fiction that the I-140 is still alive. So it doesn't matter to you. If your 485 has been pending 180 days, after 180 days of 485 pending, if the I-140 is revoked, we don't care. If it is revoked before 180 days, you have a problem, potentially.
All right.
Okay?
Okay. Got it.
Yeah.
Thank you, Mr. Raj.
You're welcome. The reason this is difficult to understand is because the law is so messy. We all know it. And even the government knows it. It's so many times we have to teach the government the law. We are responding to something similar, a case from New Jersey, where government has made a complete mess of their arguments. We were hired to respond to the notice of intent to revoke. I'm pretty sure we're going to win this case because the government itself doesn't understand how the 485 Ac21 works. So we often have to teach them the law. Don't be surprised. It is confusing. That's why I say don't make firm decisions without talking to your lawyers. Okay? Sid 11 wants to know, this is number 5 question, another frequently asked question. And I combined 2 frequently asked questions. Guys who are just logging in today, I can confirm we won't have time for new questions. Okay? We have enough on our plate, so we'll not be able to go beyond the hour. Here I combined 2 questions. There was a question from Mani Shankar, which was question number 15. They're both talking about basically the same ideas when you do an EB3 to EB2 downgrade. Okay. So Sid said, I have both EB2 and EB3 I-140s approved. But my EB2 I-140, which is older, is under a different job title and a different perm than my new EB3 I-140, for which this downgrade was filed in October. Do I need to file another EB2 I-140 under my new job title so I can avail upgrade to EB2 if it moves forward? Okay, you have presented such a complicated situation. Your lawyer should be helping you, not me. I can tell you this, what the general law is. So you have an EB2 approval, which can always be downgraded to EB3 to take advantage of the current priority dates. You also have an EB3, which you can proceed forward to file a 485 on as long as you intend to take that job. It appears to me that your EB2 is the more recent one. That's the one that should be downgraded. If the EB3 is already pending, maybe you can just downgrade your current EB2 to EB3 and request that that downgraded EB3 be filed on top of the existing EB3 I-485 right now. So you don't have to file a second 485. I think you should be able to attach the downgrade to the already filed EB3 I-140. Okay, so downgrade your EB2 not as an amendment but as a new petition and request the government to attach the EB3 downgrade approval to the EB3 original that's already pending. I hope that makes sense. Can you talk about upgrade from EB3 to EB2? Oh, absolutely. I have talked about it several times. We have several frequently asked questions on this. You can always go up and you can always go down as long as your Perm was filed as an EB2. If you filed your Perm as an EB3, then you're not going to be able to upgrade to EB2. But if your Perm was filed as an EB2, you can downgrade I-140 to EB3. You can go back, upgrade to EB2. If you already have an EB2 approval, you can file a downgrade second case as EB3 with the same Perm. Okay, so I'll cover the second set of questions also, then we can open it for further issues. So Manishankar said, my company has already filed 485, 765 and 131 along with EB2 to EB3 downgrade with new I-140. Just wondering how this process works. Does 765, 131 have to wait until I-140 gets approved? To the best of my knowledge, no. They should approve the 485 process separately. Okay, so yeah, so the process of EB3 downgrade should be separate and the issuance of advance parole and EAD should be separate. So it should go on even while the I-140 is pending. At least that is how it used to be. But there's nothing written on this. To the best of my knowledge, that's exactly how it should be, and that's been my experience as well. Okay, *5 if you have a follow-up question. *5. Okay, so we've got a question from area code 916. 916, where are you calling from?
Hi, good afternoon, Raju. I'm calling from Sacramento, California.
Yes, sir. Good afternoon. Tell me.
First off, thank you for this great community service.
Excellent.
So my question was the first one. I have both EB2 Perm as well as EB3 Perm. And then the 485 was just now filed with the EB3 Perm.
Why? You don't have to repeat the facts. I know the facts. So what is the question?
So the question is, can I still avail the EB2 Perm and file 485, even though it is under just a different job title?
Okay. Is your EB2 date current?
No.
Okay. So you won't be able to use that for EB2 filing, but I already explained that you can use that for EB3 downgrade.
Yep, which is filed already. Yep, thank you.
No. That EB3 is filed under a different Perm.
Oh, okay.
What I'm saying is file another EB3 with this Perm because this seems to be the job you want to keep doing. That one is an old job. Okay. So to take an example, if you got an EB3 approval as a software engineer, that's already pending, filed with 485. You have an EB2 as a team leader. EB2 is the job you are doing or expect to be doing. It's a good idea to downgrade that and attach it to the pending 485. Okay.
That's good. Yep, thank you.
You're welcome. Good luck. Okay, I'm repeating once again, guys. We won't have time for new questions, okay? Next frequently asked question, let's see. So this one is number 9, job change after I-140 approval before I-485 submission. So when you have not submitted your 485 and you change jobs, the only way you can file 485 is what we discussed earlier, if the old employer has the job for you, a good faith job. Otherwise, you have to start the green card all over again. You carry the same priority date, but the Perm has to be filed again with the new employer. A new I-140 has to be filed, but it will inherit the priority date of the old case. So let's see what your questions are, Shailesh. I have a Perm and I-140 approved from my previous employer. Priority date is 2015. Changed employer 5 years later, similar job. I was told I don't need to file a completely new process for Perm. Whoever told you that, if it was a lawyer, they shouldn't be practicing law. No, that is incorrect. Supplement J becomes available only if the I-140 is approved and 485 has been pending 180 days. If the 485 was not even filed, there is no question of a supplement J. You have to start the green card all over again. Okay? So, and don't try to apply common sense to law. Law is the law. And immigration law is extremely artificial because there is no natural justice in immigration law. It is based upon an institutional, a policy-based, well, here it's not even policy, but it's based upon principles that may not be easy to understand. Okay? *5 if you have a follow-up question on this. *5. So yeah, you have to start your green card all over again. No question about that. Okay, next frequently asked question. Yeah, this is another one that's coming up quite frequently. Loss of H-1B job and opting for B-2 visa. So you've lost your job. You have a 60-day grace period, hopefully, because that also has its own requirements. And let's say you have the 60-day grace period and you were not able to find a job. So within that 60-day grace period, you applied for a B-2 visa. Now, typically you'll ask for 6 months. That's all you can ask for. Before the 6 months are over, if you don't have a decision, file another B-2 so that you can daisy chain. Ask for another 6 months that coincides with your previous 6 months. So let's say the first one you filed in January and you asked for extension in June. File another B-2 in May that goes from June through December. Okay. So you have to daisy chain them. How long can one extend a B-2 until something is denied? Until the B-2 is denied, you could try to keep getting it extended. If the original one gets denied, do I get illegal presence? No. As long as a timely filed B-2 was pending, you have no unlawful presence. Not 1 day. How long would I have to leave? Well, technically you have no grace period to leave, but the 180 days begins to be counted from the date of the denial. Date of the B-2 denial, not from the date of the 60 days expiration of the H-1B. Okay? Any suggestions on what steps to take if USCIS does not approve change of status? You should file a motion to reopen and you can continue for another 170, 175 days and then leave. But I don't know if that's such a good idea. You should at that point, you should talk to a lawyer. Okay? And yeah, only emergency visa appointments are available right now, even though you are a Canadian resident. But ultimately it will only get better. I'm hoping that they get their processes streamlined. Not every person should have to be physically interviewed, or they could do Zoom interviews or some kind of, really, your physical presence at the consulate should not be required. But we'll see what happens. I have high hopes for the Biden administration because these are intelligent people as opposed to a bunch of doofuses running the government under Trump. So hopefully we'll have more intelligent people running the government who can find practical solutions. Let me just make sure we have no follow-up question. *5 if you have a follow-up question. Okay. By the way, I just had to share this with you. Pompeo, the Secretary of the State Secretary, the guy who runs the Department of State, which is the consulates, he had a party. So he sent out 900 invitations. By that time Trump had lost. So out of 900 invitations, only 72 people sent their RSVPs. And out of that 72, only just a few showed up. So this guy who wanted to have 900 people during COVID-19 times, talk about doofuses. Why would you want to do that? But ultimately, it was kind of funny to have, just a handful of people show up to a 900 people party. But that's who is running your government. Delay litigation and mandamus. Okay, so this one is a question in relation to H4EAD's delay, H4EAD and H4 delays. But this is true for any delay cases. Sometimes, if the government is delaying too much, you can sue the government. And we've done this many times. We've done H4EAD delays also. We've slowed them down because if you've not been called for biometrics, it might be more difficult to win those cases under COVID-19 environments, but it can still be done. So in delay cases, we look for whether the delay is extraordinary. And if it is extraordinary, for example, H4EAD delays, I think I can sue after 6 months of pendency. More is better, but at least 6 months I can sue. Okay. Or 4, 5, 6 months I can sue. Then for something like 485, maybe a year, 2 years pendency. So it's different for different cases. It's kind of difficult to make a general rule. But the difficult question is, should we sue in Washington, D.C. or where the case is? So if your employer is in New Jersey, should you sue in Washington, D.C.? So far, we've been suing in Washington, D.C. because that's where the government lives. And oftentimes, that's where the policies are formulated. So it's the right place to sue. But sometimes suing out of Washington, D.C. could be problematic if the government wants to move the case to another jurisdiction where you live. That can cost you a few weeks delay in the litigation about delay, as well as additional expenses of having to hire another lawyer who can help you fight locally. So yeah, we are still doing delay cases if needed. Success rate, ours is pretty good, 100% so far, but that cannot be guaranteed. You never know how long it's going to take. But hopefully we can write a complaint that is persuasive enough that the government wants to settle the case with us. And that's really the ideal circumstance. If you have to go all the way into summary judgment and actually fighting the case out, you already would have lost a few months. At that point, I don't know if it is even worth fighting, because part of the reason is we are fighting delay, and the case would have been delayed so much that your case is already approved by the time we get to any point. So delay litigations are useful, highly useful, but not in all cases. Okay. *5 if you have a follow-up question. *5. Okay. So let's go back to now our routine questions. And we have about 23 minutes. I'm going to try to cover everything. So this question I do not know the answer to. It's a little too complicated for me to give you a snap answer whether a CSPA applies to these circumstances. Okay. Because you first had your case denied. At that time, the child was under 21. By the time they reaffirmed, he's now 23 years old. So I'm not sure how the law applies to this. I have to read up on it. I have to look at the law, look at the regulations, look at the decided cases. You may want to talk to your lawyers. I don't have an answer. Sorry. Next one is, this is question number 6. H-1B and green card process with a payroll issue. So you have a time in between jobs where you were neither on A or B payroll from 3rd to 25th. I don't think that's a problem. I don't think that's even out of status. Okay. So you started H1 with the current company A on 15th October 2017. Your last payroll was 2nd November. The new company's payroll started 26th November. I don't see it as a problem. Okay. So as far as your status is concerned, I'm not worried. I think you'll be fine. So no worries at all. *5 if you have a follow-up question, Vidya. *5. Okay. Let's go on to the next question. This is a state of forces agreement. Okay. For you, ma'am, I would recommend that you Google expedited naturalization, also expeditious naturalization. You will be shown a bunch of documents. What happens is, if somebody's spouse is working for the US government abroad and the employment is going to go on 1 year beyond the date of interview for your naturalization, you can actually get naturalized as long as you are in the United States holding a green card when you file your naturalization application, and then you come back for naturalization to USA. They will not care about how many years you held a green card and whether or not you have 2.5 years of physical presence or 1.5 years of physical presence. So for expeditious naturalization, the rules are very different. That's all I can tell you. Each case is different. Each case should be looked at separately. But if you Google expedited naturalization and expeditious naturalization, you will find plenty of material. That should give you enough to get started. *5 if you have a follow-up question. *5. And yeah, we've done a bunch of these. They are not that complicated, just additional requirements, that's all. So this one is moving to Canada with an L1 visa. The problem is, he's got the L1 approval. Nandan is a resident of Canada, but he can't get an appointment to get a visa. Okay, so can he go to a third country? Yeah, if the country is taking applications for L1, double check with them before you go, and you meet whatever their isolation requirements are. You can definitely go to any country. Okay, but other than that, all you can do is wait, because if you don't meet the emergency criteria and you're not willing to travel to a third country, you just sit and wait until the borders are, or at least the visas are opened again. If you were a Canadian citizen, things would be a lot easier because you don't need a visa. Okay. *5 if you have a follow-up question. Okay, good, you're here. Area code 404, where are you calling from?
Hi, this is Nandan. I'm calling from Vancouver, Canada.
Haji, Nandan. I don't think your wife's semester start date is necessarily a good reason for your case to be expedited. Okay. And I would rather not link your case to your wife's case.
Okay, yeah, thank you so much. And on the travel, I know that when we book the appointment, there's a specific question on whether you're traveling for this visa appointment. So if we are traveling outside the country for a visa appointment, is there like a higher chance of the visa being rejected?
I think the chances are about the same. Okay. I don't think the chances matter whether you are applying for a visa from one country or another, if that's your question. Okay. Change of status is not possible. Yeah. So I think it's...
Yeah.
Go ahead, Nandan.
Sorry, didn't mean to interrupt.
No,
I was just wondering because there isn't any business ties or personal ties that I have within those countries. So I'm just concerned if the visa officer would consider that I'm just trying to go to an easier visa approval location to get approval for my visa.
The reason for your travel is not forum shopping for the possibility of visa chances. You are forum shopping simply because visas are not available elsewhere. Okay. So I think there's a difference there. I don't see any problem. All right.
Okay. Thank you.
You're welcome. Okay. So we've done this already. And then this is from number 10, question number 10, Advanced Parole and EAD Renewal Applications. Shri says, my priority date is 2010, I'm on EAD. In August, I submitted AP and EAD renewal. They accepted AP, rejected EAD due to insufficient fee. Submitted again EAD, did not receive receipt notice. Yeah, their receipt notices are really delayed. They could not find your application. What are my options? Well, I think you could do two things. And I'll probably start with straight away going to the USCIS Ombudsman. So if you Google USCIS Ombudsman, O, M as in Mary, B as in boy, U, D as in doctor, Ombud, then S as in Sam, and man as in man, woman, M-A-N, Ombudsman. So open a case with an ombudsman. They provide kind of a watchdog support over USCIS functioning. Let's see what they suggest. Let's get it out of the USCIS environment as well. Okay, I would do that. You can also contact your congressman's office, see if they can assist. *5 if you have a follow-up question on this. *5. Okay. EAD 2009, this is question number 11. In June 2011, my H-1B was approved. Extension of stay was denied. I left USA within 2 weeks. Went to New Delhi, got my H-1B in September 2011. Came back in December 2011. And then from June to December, I went from one city to another, not living more than 3-4 weeks at one place. Oh, so you were outside USA. Okay, so you went New Delhi, in-laws, went to Europe, came back. Okay. I filed the 485 application in Feb 2012. In G325A, I filled my address from June 2011 to December 2011 as my old address in New Jersey. I did not fill various Indian and European addresses. I think what you should do, I don't think it's going to be a major issue. It can cause some RFEs and delays. When you get the receipt, you should open a service request with the government saying, look, I want to reflect several locations in my G325A paperwork. How can I submit an amended G325A? So at least put it on the record that you tried. Let us see what they say. But you should try to get it corrected. I don't think it's a major issue. Yeah, and we don't go to immigration courts. We go to federal courts. Immigration courts have no business here in this kind of a situation. Okay. So yeah, that's what I would do. I would contact, once I have the receipt, I would contact USCIS customer service, open a service request, telling them I want to change my G325A entries. *5 if you have a follow-up question. *5. Okay. So, per country quota limitation for employment-based immigrant. Well, I've recently started writing for the Economic Times. I have so far published 2 opinion pieces. One, I talked about how Trump is destroying the immigration system, not disrupting. The second one that I wrote was about how Facebook's immigration complaint is odd and actually suggests certain things that could be gleaned easily from somebody, by somebody who knows what's going on in immigration law. The next article that I'm preparing, hopefully, would be about this quota system. Now, as you would know, there are 2 different versions of the green card quota systems pending in the, well, actually not pending, but passed, one by the Senate, another one by the House. The House version is better, the Senate version is worse. But don't start, see, I don't even follow pending bills until they are getting somewhere. These are too far apart. The Senate and the House versions are too far apart. I don't know if they're going to go anywhere. Okay. But it does give me some hope, and I think I intend to point that out in my comment to Economic Times, that it gives me hope that there's keen sensitivity in both chambers, Senate and House of Representatives, that these delays are too much. You know, these decades of delays for green cards are unacceptable. Something should be done. So right now, that's all I can tell you. I can't tell you anything more than that. There is nothing certain yet. When things become a little bit more crystallized, I will, of course, post in social media. Follow LinkedIn, follow our web pages, immigration.com, follow Facebook, follow Twitter, whatever is convenient. I have accounts on all of these places, and you can see my social media links on immigration.com, top right hand side. Okay. So yeah, so I'm not prepared to comment about specifics of what the new laws could be. I don't know when they are going to be or what they're going to look like by the time they are done. Currently, Ac21 Portability needs at least initial 485. Yeah, they had some of these provisions for early 485 filing, etc. So, I mean, again, until something gets passed, I can't tell you what it's going to look like. So I'm not prepared to comment about that at this time. Folks, people who are logging in today, just now, I will probably not have time for new questions. So please be aware of that, okay? So we already did this question. Oh, we may have time for new questions. Okay, any follow-up question on this question number 13 that I just oh, not 13, sorry. Question number 12 that I just discussed? Any follow-up question? Okay. All right. Oh, there is one. This is from Pennsylvania, I take it. Are you calling from Pennsylvania? 261? 267?
Yeah, hello.
Yeah, go ahead, please.
That was my question.
Right.
I totally get your point. That was my question. So yeah, we should wait for it. I was too early to do that. So
yeah, let me interrupt you for 1 second. So when a law governing the same subject area is passed in two different versions by the two chambers, House has a version, Senate has a version, they usually form a conference of both houses, both chambers, who sit down and try to reconcile the two versions, negotiate, and come up with a final version. That then gets voted upon by both chambers again, and that's when we know the bill has been passed. And if it were administration like Joe Biden's, where you can expect consistency and intelligence rather than, oh, today I don't feel like signing something, I'm not going to sign it, which is the Trump's way of doing things. I mean, he agrees to something, Chuck Schumer and Nancy Pelosi walk out, 10 minutes later he says, oh, I never agreed with this. So you can never trust an administration like that. Hopefully, we have more consistency and predictability with Biden administration. Hopefully, they are aware of the laws that are being passed, and that's how it should be. They are involved, and they push their provisions and try to be actively involved in bringing resolution to any differences. That way we know when it goes to the president's desk, it's going to get signed. So right now, we are too far away from all of this. Go ahead with your questions, please.
Yeah, no, that's okay. So that's what I was just trying to say, that maybe there could be that this 2-year I-140 approval thing is compromised, or it's not, because it is not in the House version at all, as you said. It's only in the Senate's version. I don't see it.
Yeah. Yeah, another thing I didn't like about the Senate version was the 9-year cooling time as opposed to 3 years. So there were some things, and they were really killing the H-1B visas. See, what bothers me is that how can you make these decisions without studying the problem? It is pathetic. Some of the new tax laws that came out, it was revealed that almost 70% of the legislators had not even read what they were signing. Okay, so sometimes it's very disappointing how unintelligent these people are, especially on the Republican side, I must confess. I won't say that that's true for the Democratic side, because I think we are generally more intelligent. Okay.
Okay. Yeah. Fine. So just one question I had was, in case I just out of curiosity want to see about my I-1, as you said, I-140 doesn't have to be withdrawn by the previous employer. Is there a way that I can just check it online and see if it's still approved?
See, here is the problem. Yes, you can enter your receipt number and you can find out, but is that dependable? And I don't know the answer to that question, because even if it says your I-140 is approved and it doesn't change any notification after that, I don't think I can guarantee that it hasn't been revoked. Easiest way and the most reliable way is to just call your lawyers and say, did you guys revoke this? Or did the employer ask you to revoke it? Okay.
Okay, I get it. Yeah.
All right.
No, I mean, I'm just being prepared in case the date were to become current. I need to know, if they revoke it, there is no point even asking them back. But if they did not, then maybe there is worth asking that, will you be interested in filing supplement as a future job, right?
Absolutely. I don't see any problem with that. And I'm trying to think, come to think of it. So even if they revoke, here is the interesting question. Why can't they refile the I-140? So even if they revoked, they could probably still use the same Perm application, refile the I-140, and because the dates are current, also file the 485.
Oh, I see. But wasn't there something like a policy that the Perm has to be within the 6 months or something? That's what the
No. That's not how it works. So when you file your I-140 for the first time, you must file it within 180 days of Perm approval. Okay? If later on you refile, think about it. Otherwise, how do you downgrade your Perm from EB2 to EB3? You are still using the same Perm.
Oh, that's...
Hai. So when you do a subsequent petition, you don't have to be within 180 days.
180 days. At least once it has to be filed after the approval.
Okay. Even if it gets denied, you still can keep filing with the old Perm because you have met the threshold one time. That's all that is needed. Okay?
Yeah. So yeah. Thanks a lot.
All right. Good luck to you. Guys, I have only 3 minutes left. So I'm not going to have time for new questions, because there is one I will answer. Somebody had their hand up from Pennsylvania. So this one I will answer, but then we are done. Pennsylvania, go ahead, please.
Hi, Rajiv. This is for the first question FAQ. So I understand, in case of after filing 485 and before 180 days, and if I get terminated, you said if the employer is revoking, right, then 485 might be in trouble. So that is one scenario you told me. Say in case of instead of termination, if I'm going to quit the job, right, and still is it going to the employer can revoke it, my H1, or that is a different scenario?
I don't understand the question. By the way, I see a number of hands up, guys. I am sorry, we don't have time for new questions. That's why I advise people to post online so that you are guaranteed your answers, pretty much. Okay, sorry guys, I just don't have enough time today. Okay, go back to your question. I don't understand that question.
So the first question, FAQ I posted. So this is scenario 485 filed and before 180 days, pending 485. And in case of termination of the job, so you said employer can go and revoke H1, then that might trigger 485 to
exactly.
Wrong.
Exactly.
right?
Exactly.
So that is one scenario I understand. So instead of termination, say like if I'm going to quit the job, I have some issue with the manager, and then say I quit the job, then employer can still take the route of going and revoking my H1, and that is going to trigger the 485 filing.
See, whether you quit,
scenario, or
I don't see how that makes a difference. Whether you quit or you are laid off, employer could still take the route. In fact, they are required to revoke the H1.
Okay, so in either case, like a layoff or quitting or termination,
Yeah.
all those fall into the same.
Yeah. Okay. All right, I've got to go on, guys. All right.
Okay, Raj.
Good luck.
Thank
Okay, here's what I'm gonna do, guys. There are two people who have been waiting almost an hour. There's one person who's been waiting 8 minutes. I'm not gonna answer the 8 minutes. I'm gonna answer the two people who've been waiting almost an hour, 56 minutes and 54 minutes. I'm gonna answer their questions. So let's go ahead and do the area code 224. 224, where are you calling from? 224?
From Chicago, actually.
Chicago. Yes, sir. What is your question?
Sir, if I apply for H1B transfer for two companies, like company B and company C, and both get approved for 3 years, I join company B, and after 6 months I join company C without any H1 transfer from B to C. Will that work?
To the best of my knowledge, it should. Because the regulations have created a situation where this is not entirely clear, but there is a parallel. The regulation says, let me explain to you why I think what I think. The regulation says, let's say you are working for company A and you filed a transfer to company B. As soon as you filed the transfer, you joined company B with receipt, because you're allowed to, right? If company B's case gets denied, you can come back to company A. So what is the difference between that situation and your situation? Theoretically, there's no difference. So in my view, you could actually come back and start working for company A again if they have not revoked your H1B. Okay?
Yeah, that is fine, sir.
Good luck.
Thank you.
You're welcome. Okay, so the last question we are answering, well, this one is 43 minutes. I don't know what happened. If your hand was up, you've been logged in for over 50 minutes. Put your hand back up again. Press *5. If you've been logged in for more than 50 minutes. Okay, yeah, your question I'm answering. I'm not answering any others. This is New Jersey. Okay. No. There's 143 minutes. Okay, I'll answer yours also. So you are calling from Texas. You stay on the phone. And I'm going to New Jersey next. Okay. Area code. Oh, wait a second. What did I just do? No, this is the wrong one. I am going to take that one out. That is just the 11 minutes one. So, oh God, this is difficult to keep track of. Area code 201. Which one is area code 201? I want to go to 848 first. Okay, let's go to 848. 848, go ahead with your question, please. 848.
Thanks, Rajiv, for taking my question. My wife is in her 6th year of her H1B. Her Perm got approved, and she has RFP for a I-140. Their employer responded to the RFP. Her H1B is coming to an end by 12th of January. So, like less than a month. So, what would be the best course of action for her?
Okay. So what you do is you get an LCA approved for her for 3 years. Okay. So that you are ready to file the H1. Get the LCA approved for 3 years and then wait until the last week. In the last week, if you don't have an approval of the I-140, But you have, your Perm has been filed 1 year ago. When was the Perm filed?
Perm was filed in the month of May this year.
Okay.
It's not been.
So she's not entitled to any H1 extension until at least May, or until the I-140 gets approved. So have the LCA ready. If the I-140 doesn't get approved, you'll have to convert her to H1 till May. In May, she can at least get, even if the I-140 is still pending, she can get 1 year H1 extension. Okay.
And if I-140 gets denied in the worst case, is there anything that she can do without leaving the country?
Yes. Listen to me. So what you do is you file an appeal.
Yeah.
While the appeal is pending, she can still get H1 extension for 1 year in May.
I see.
Okay.
Okay.
Anything else?
Thank you very much.
You're welcome. Good luck. Okay. So now we have one that has been 201. I'm not answering any other question. This is the last one, guys. These guys have been waiting almost an hour. So 201, go ahead, please.
Thanks for taking my call, sir. So this is my question. My mother was here on B2 visa on February 2019. So due to COVID, we had to extend her visa for 6 months, which is until February 4th.
Okay.
Because of her pre-existing medical conditions, we would like to extend further.
Right.
Is it possible to extend?
Yes.
Her current
Yes.
application is in process?
Yes. Because you asked for February, you can apply for another extension from February to 6 months more and do it now. Okay. If the first application gets denied, she'll have to leave. But if the first application still remains pending, after February, she can continue to stay because she has a second application also pending.
Okay.
That's the smart thing to do.
Will it have any?
Yeah, will it have any consequences on the future? Well, first of all, she shouldn't come back for at least 1 year after she leaves. But other than that, I mean, this is not something she's doing because she wants to stay. It's because she's stuck. So I think we'll be all right.
Yes.
Okay.
Thank you, sir.
You're welcome. You're welcome.
Since her current application is in process, was
Right.
concerned whether we could apply for.
Yeah. Go ahead and that is the smart thing to do. You have to do that. Okay.
Okay. Thank you, sir.
Good luck, ma'am. Okay, guys. I have to run. I answered as many as we could. So I'll see you again in 2 weeks. Thank you all for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.